But anyway, on to business.
On to business,
What
yes.
did you do?
What did we do? Well, we first went into the High Court. We thought we'll just pop in there and have a wander around.
Have a look. Say your day.
And sort of this magnificent old building on the Strand in London, which is pretty much just off to the left. If you look directly at a map of London, it's the west side of the city. Yeah. And the Strand is just a stone's throw from Australia House.
Oh, nice.
And that was a bit of a shock going to Australia House. But, because we had to serve papers on Australia House. So basically we went into the High Court and we just sussed out the law of the land there and the procedure. Yeah. We discovered that because our application was going to be under habeas corpus, which was with respect to the senators being restrained in Australia from going to London to present his dilemma that he's been placed into relating to his position as a senator. Yeah. So he was restrained through the bankruptcy order. Yes. And the trustee for bankruptcy, which was appointed by the Australian Financial Authority, because he was not volunteering to do the statement of affairs. Yep. So he was kicking up, of course, so they put a restraining order on him essentially by not issuing the passport. So the trustee was saying, no, I'm not going to issue the passport. We got that in writing. Yep. And that was then evidence that he was restrained. Yep. And so we then took that as an application to England under the 1816 Habeas Corpus Act. Yep. Which is, all of these are laws of England as such. Yep. The original habeas corpus is 1640, but we were relying on the 1816 one. So we made our initial application into the High Court. And they knocked us back straight away at the registry because they said, we just don't have a jurisdiction. You're a foreign country. I said, well, on the paper it says that we're relying on the Commonwealth of Australia Constitution Act 1900 UK.
Exactly.
Do you want to get any more blatant than that? So this girl, for about half to 3/4 of an hour, she was just running from the registry office around some. It's just like Harry Potter's the school. I can't think of the name. Hogwarts. Yes. It's just like that. It really is. The stairs, these incredible stone, this amazing building. So she was running around. The lawyers were then sending her back and saying, no, we don't care about this being a UK law. Too bad, so sad. And I was just saying, well, no, this can't be the case because of the habeas corpus. This is still applicable, and it clearly says that in this 1816 Act. Yes. So UK courts have to deal with it. Yes. If the courts of the colony can't deal with it. And we've got evidence that this is so. So she'd run back off again. And, that's the last effort she did lasted the longest. And then she came back and she was clearly frustrated, She's just like, no. The lawyers are just saying, no, we can't accept this sort of thing. And then she mumbled, unless you do an insistence form. And I said, what was that? What was that? I didn't catch that. Unless you fill out an insistence form. Beauty, where is it? So I filled out the insistence form. I'm insisting that this be filed.
Yeah, is that like the I strenuously object?
Yes, that's the one. So I've filled out this insistence form and I've handed it over to the registry, and you could see they weren't happy with this, and they're just sort of like, do you realise that costs could be imposed? And I said, really? So who would be imposing the costs? They couldn't answer that one. So I was just like, all right then. So they went through the process and they stamped all the paperwork.
Nice.
And they filed it, and it was like, wow, this is awesome. Okay. So we took it outside and we went to a pub just over the road. had a coffee and took photos of the paper.
Coffee?
Yeah, we had a coffee, yeah.
With a bit of Guinness.
No, I wasn't down there. Mr. Gargan was definitely in that road. But took photos and then got on to Rodney and sent it all over to him.
Yeah.
And being a habeas corpus application, it was supposed to be heard instantly, but they've done a lot of changing in the UK. And funnily enough, in 1973 was when the UK joined the EU. Gee, isn't that
yes.
Is that a coincidence or what?
Must be.
1973, Australia has been basically let loose.
Yeah.
And it was Heath, Prime Minister Heath, who conspired with Whitlam.
Yeah.
And one of his attorney generals or something, and there was another couple of people. We've actually got a Hansard of this.
Yeah.
And they were discussing a couple of years prior, 73, how they were going to bring about this disconnection of Australia from the Commonwealth, so that the United Kingdom could then join the EU.
Yep.
And they actually had a referendum in the United Kingdom to join the EU.
Yeah.
And there was something like 62% voted for going to the EU.
Yeah.
And this was the Labor Party that brought all this about in England. So they then got approval. They ran the disconnection clause, and England joined up with the EU. And of course, Australia and Canada and the other Commonwealth nations were sort of left lingering with this paper queen that had been submitted.
Yeah.
And they were basically then, this is when the Unidroit Treaty come in, and they were then handed over to Rome. So all of the Commonwealth nations were handed over to Rome through the Unidroit Treaty.
Yeah.
England had been part of that since 1948.
Yeah.
But they'd never actually completely kicked over to the EU because they still had their gold-backed pound, their pound, shillings and pence. Their currency was not Reserve Bank, but they were able to utilise the euro. So, of course, they were running these two currencies. And that there's actual paperwork we've got that shows that this was all done without proper due process, especially with relation to the Commonwealth countries. And that's sort of given us a foot in the door. So we have cited some of this in our paperwork in the affidavit before the High Court. The High Court we then, because we were still learning as we were going. And we then cited that in order to get it in front of the Privy Council, because we were heavily relying on Section 74 of the Commonwealth Constitution. Yeah. And the Commonwealth Constitution gives us that inalienable right to go straight in front of the Queen in Council, which is the Privy Council. Yeah. Even though the Australia Act had taken that away, Section 74, while it's still there, has to be seen as a valid piece of law. Yeah. So you've got these conflicting laws. Yeah. We utilised mainly Section 74, and we requested an uplift straight to the Privy Council. Now, the Privy Council, since 2009, has been situated in the Supreme Court. Okay. In the United Kingdom. Yeah. So the Labor Party in the United Kingdom have been diligently working away over the decades to erode away the House of Lords. Yeah. Right. Which is our Senate as the equivalent. But the House of Lords in England is they're lifetime peers. Yeah. They're appointed. Yeah. So anyone can actually, in England, anyone can apply to be a Lord. Yeah. Okay, there's a process you follow. There's now a website you can go to and you can fill all in. And there's basic requirements you have to fulfil. There's over 850 Lords. Wow. In Lord the House Vader in there? No, Lord Vader. I don't know. I really haven't looked at that side of it. No. But there are special interest groups within the House of Lords. Yeah. But in 2009, the Labor Party's further push to whittle away more powers, they then handed over, because there are some lords that sit in the Supreme Court. Now, the Supreme Court in the UK is not a court you can go straight to and start a case. It is only there as a court of appeal. So the High Court in England's not equivalent to our High Court here. It's called that. But it's not the same sort of thing. Our High Court is the highest court we can have access to. But in England, that equivalent would be the Supreme Court. Okay. So we then we put what's called an uplift application into the habeas corpus. Because of the jurisdictional grounds, using Section 74. So we were saying, we realise the High Court's not able to really rule on this, but we want you to give us the next step that we need in order to fulfil Section 74.
Correct,
Which is, so they basically got back to us. We filed the first one on the 15th of January, and then on the 25th of January, we updated the paperwork because we included, and this was against the Commonwealth of Australia. But on the 25th, I updated the affidavit to include the Crown. Okay, because essentially the Crown is responsible. And the Crown is the United Kingdom. Okay, so the United Kingdom cannot be seen as a state of the Union. Right, or a colony of the Union or a dominion. No. The Crown is a specific jurisdiction in itself. So and because this is where the contracts are drawn from to create the colonies, therefore they are answerable to each one of those political union members. And this is why we included the Crown. So then we had to find the office to do all of that and file the paperwork with the Crown. And they accepted all this, no problem. But the courts, they don't rely so much on people standing in front of them in a courtroom anymore. It's all pretty much done in chambers. So the High Court made a ruling, and they in the ruling they cited my name as the applicant representing Senator Rodney Cullerton.
Wow.
Senator Rodney Cullerton.
There you go.
They cited him in his capacity as they recognised him as a senator.
Wow.
And then they stated, well, we don't have jurisdiction because of the 1862 habeas corpus.
Okay.
Right, that was their reasoning. They said, no, because of this legislation, we have to knock you back. And they said, essentially, the 1816 gave us the right to go to England, but the 1862 took that right away. Okay. And the 1862 Act says in Section 1, writ not to issue out of England into any colony having a court with authority to grant such a writ. Right. So this essentially brought the onus back to the courts here in Australia. But what we were showing beyond any reasonable doubt was that we'd lost all of our courts here.
There were no
we had
courts.
None. They weren't under the Crown. So therefore they were star chambers by definition. But then we discovered after a bit more searching, and I must, this is where our researchers back here in Australia, Darren and specifically, Darren Dixon, found that there was a piece of legislation in here in Australia and in England which said that if any part of a law has been repealed or amended, then you can cite this section and bring it back.
Bring it back. Oh, wow, nice.
But the key words are as of right.
Yes, very powerful.
They're the key words. And we then searched. I was then able to go through the English legislation and the civil procedure rules and back that up. So I was able to then take what he'd discovered, put it into a form that they recognise through their rules. Not so much their laws, but their rules, because they run...
Yes, everything, as we know. Yeah.
As we know. So then I brought that in.
Mm.
So that way I was just shutting the door.
Yeah.
So they couldn't move. And appealing her decision, which is part of what we wanted to achieve anyway.
Anyway, yeah.
I mean, her decision was very good. It left so many open doors.
Yeah.
It was like, wow, she's doing us a massive favour here.
Yeah.
And so then on the 29th of, the 6th, we filed of February, we filed the paperwork with the Supreme Court.
Yeah.
Now, we could never have got into the Supreme Court
the other way.
Unless
we were appealing.
Yeah. So we'd made the effort. We got the judgment. Thanks very much. Now we'll go to the next level.
Which is where you wanted to go anyway.
Now, the only time this has been done since 1980 is 2003.
Yeah.
And it was a barrister by the name of David Fitzgibbon, and he took a case into the High Court, and they threw him out and broke his fingers.
Right.
So they basically said, no, you guys have got no right to be here at all. Piss off, sort of thing.
Yeah.
So what we've done is made up for his mistakes.
Yeah.
And you've really got to be there. You have to be there. You can't do this stuff online.
No.
You really can't. You can't do it on the phone.
No.
It's just... Be there or forget it.
Nice. All right. Well, I know you've got lots more to share with us, and obviously, most importantly, what the ramifications of this are now.